Aisha works as a secretary in a private company. One day, as she eats lunch in the cafeteria, she is approached by Siraj, a colleague from another department. He sits down at her table uninvited and starts to tell her about how he is unhappy in his marriage. He goes into graphic detail about his private life. Aisha is deeply uncomfortable with this. She wants Siraj to stop but is afraid to ask him. He works at a senior position and Aisha has only been working here for 3 months. She quickly finishes her lunch and excuses herself. But it doesn't end there. Siraj manages to get her number and starts sending her personal messages. Aisha deletes the messages without responding. Unfortunately for Aisha, Siraj is a good friend of her boss Ravi. Siraj visits Ravi's office often. Somehow, he always comes when Ravi is in a meeting or away for lunch and tries to chat with Aisha as he supposedly waits for Ravi. It soon gets unbearable. But Aisha feels like she cannot complain against Siraj because he has never touched her or made any verbal sexual advances directly. And yet, Aisha feels violated. She remembers then that her friend Reena studied law. She finds Reena on a social media platform and writes to her about her problem. Reena writes back to her that despite the lack of overt sexual advances, what Siraj has subjected Aisha to counts as sexual harassment and that she can formally complain against Siraj. The Indian Penal Code defines sexual harassment as a situation where a person makes any unwelcome sexual advances towards a woman, demands or requests sexual favors from a woman, shows pornography to a woman, or makes sexually colored remarks to a woman. The gang rape of a Dalit development worker in Rajasthan in 1992 and the court case that followed it led to the Vishaka guidelines that codified the law on workplace sexual harassment for the first time in India. As a result of this case, the Supreme Court acknowledged workplace sexual harassment as a human rights violation. A 2013 Act defines the problem, identifies possible victims and stakeholders, and outlines the procedure to be followed in such cases. An important addition of this Act is the setting up of complaints committees at the internal and local levels. Employers should set up an internal complaints committee or ICC that is headed by a woman and half of its members should be women. It should also involve a member of an NGO with knowledge of the issue. Employers should inform employees about the existence of the ICC and also explicitly communicate the intolerance of harassment in the workplace. According to University Grants Commission regulations, colleges should also have ICCs that will look into complaints by students, teaching and non-teaching staff. An aggrieved woman should file a written complaint with the ICC within 3 months of the incident. If she is unable to do so, another person who has knowledge of the incident may do so on her behalf with her written permission. The ICC may attempt a settlement that is not monetary between the complainant and the accused if the complainant requests it. If a settlement is reached, there is no enquiry. But if there is no settlement, the ICC will initiate a formal enquiry. During the inquiry, the ICC has powers akin to those of a civil court and may summon people as required. During this time, the ICC may also recommend that the employer transfer the woman or grant her leave or not allow the accused to supervise her work if the complainant requests such action. If the accused is found guilty, the ICC may recommend suitable punishment. It may also recommend monetary compensation to be made to the victim. If the complaint is found to be false, the committee may recommend action against the complainant. Due process is to be maintained throughout the procedure. The proceedings should be confidential. The complainant should not face any repercussions for choosing to file a complaint. Now that you know all this, where do you think Aisha's case stands vis-à-vis the 2013 Act if she chooses to complain against Siraj? She can write to the ICC about her troubles and get them involved. And there is hope for victims like her. In a 2019 judgment, the Delhi High Court upheld the University of Delhi's Complaints Committee's finding that a professor was guilty of sexually harassing his student. But Aisha might struggle to get proof as she has deleted Siraj's messages and all their other interactions have taken place without any witnesses. And this is a big issue with harassment cases. It is difficult to prove, or for that matter, difficult to even define comprehensively. Bear in mind that even when a person has evidence, the court may not rule in their favor. In a case where the petitioner submitted a letter as evidence of a man sexually harassing her, the Supreme Court, in its judgment delivered in 2008, said that writing a letter is merely appreciable in nature and does not amount to harassment. Echoing the court's opinion, some people may argue that even Siraj did not intend to harass Aisha and that she misunderstood his efforts at a harmless friendship. But with harassment, what matters is the effect an action has on a person, not the intent behind it. And so, we'd like to leave you with a few pointers. 1. Always be professional when interacting with workplace acquaintances. 2. Do not dispose of evidence like emails and messages, as these may come to your aid if you choose to file a complaint. 3. Encourage open discussion about harassment and its nuances at your workplace. These nuances are beyond the scope of this video, which is meant to serve as an explainer on the law and policy related to workplace harassment. But we leave resources that go into this in detail in the description for you to go through. Do share this video with your colleagues, friends, and family to spread the awareness. And thank you for watching.
Subscribe to Factly and hit the bell icon for updates.